I'll call the third case on this morning's docket. It is case number 115904, Kedren Littlejohn v. State of Kansas.
May it please the Court, Assistant District Attorney Boyd Isherwood on behalf of the State of Kansas. And Chief Justice Ness, I'd like to reserve 3 minutes of rebuttal time, please.
3 minutes is granted.
Thank you. So, a little stroll down history lane might be in order. A movement in a 60-1507 motion is presumed to have listed all grounds for relief, and a subsequent motion need not be considered in the absence of a showing of exceptional circumstances. The reason behind this long-standing rule has been stated that there's some degree of finality in the criminal process must be achieved so that the endless piecemeal litigation will not interfere with the timely dispatch of business of the courts. These are your historical rules, rules that you have applied for decades. They are fair. They should have been followed by the Court of Appeals, but they were not. That's what brings us here. And most recently, they were in fact followed by this court in Wynn, which is the case that we filed a 609 on. Now the question, and I know that it may be improper, and it doesn't happen very often, but the question I have for you is, how is the Court of Appeals opinion that you're reviewing today uphold any of those prior cases? What we have in Littlejohn is the Court of Appeals summarily dispatches with the concept of successive 1507s. Instead of applying the known case law on successive 1507s, the Court of Appeals indicates, well, hey, here's the thing. If the movement can allege specific facts that if proven to exist would be true and would entitle him to relief, then he, in fact, is entitled to a hearing. That is the same exact claim that any movement needs to show to be entitled to a hearing. And it completely eviscerates all of your cases that indicate that in a successive setting, you have to bring all your claims at one time. If you want to bring a successive claim, you can, but you need to find some kind of an exceptional circumstance. What happened in this case is that's why it was denied. It was denied by the district court because there was no expression of an exceptional circumstance. In fact, in this case, there was a 1507. It went before the district court judge. It was denied. It was appealed. It was voluntarily dismissed. 2 weeks later, there was a new 1507.
No, you mean the appeal was dismissed?
That's correct. Yeah. After docketing, the appeal was dismissed. 2 weeks later, there was a new pro se 1507 that was filed. And it was dismissed because while it acknowledged that it was a second 1507, it expressed no reason as to why the allegations in the second motion couldn't have brought in the third, couldn't have been brought in the first motion. That's where we find ourselves. We simply asked this court to follow its rules. Unless the court has any questions.
The Wynn opinion found exceptional circumstances for inter alia, inability to communicate in our language. How would that compare to, the allegations here are borderline intellectual disability type of thing? How would that relate to the language barrier Or you understand what I'm
No, I
saying? We're
completely
saying Wynn had a
understand.
language barrier. That was an exceptional circumstance. Well, that wasn't the only reason, but that
That's
was
correct.
one of the reasons. And so I'm asking you if there's any analog there with the intellectual disability displayed by the move-in here.
Sure. And I'll answer it in two phases. First phase is that literally has nothing to do with what the Court of Appeals found. Second phase, when we ask you to follow your own cases. Second phase is, should you get there somehow, we've got a real problem here. We've got a claim of mental retardation on behalf of the litigant. And then we have an allegation that this motion that he's filed, the second motion, was a pro se motion. This motion was better drafted than things I do. So we've got to find out what we're doing here. Are we going to live in the fantasy world where he's pro se and therefore gets things liberally construed, or are we going to live in reality where someone has represented him on this? And to also answer your question, if I may, Justice Johnson, is I don't think when you look, and this kind of goes into whether there's actually a culpable claim, but I think it answers your question too. When you look at the actual facts of this case, vis-a-vis a claim of mental retardation, here's a guy who understands a lot of things. He understands the concept of, hey, if you help me, I'll give you money. That's an advanced thought. He also understands that once this crime goes bad, oh, I forgot my phone in that car. That phone is going to link me to a crime. I need to retrieve it. But he doesn't just stumble in and retrieve it. I, knowing that what I've done is wrong, needing to retrieve that phone, I need to give a false name. I give a false name. Not only do I give a false name, but I've come up with a story about how my phone is in that vehicle that ties me to this crime. Now, these are facts that are readily available in the established facts of this case that I think pretty much cut against the concept that this person, this movement, is suffering from a mental retardation to the point where, for Justice Johnson's purposes, doesn't seem to comport with Wynn, but for the colorable claim purposes, doesn't seem to comport with someone who couldn't form the requisite intent, which is kind of the end run argument here. And on that end run argument here, the Court of Appeals indicates the defense at trial wasn't he was a victim. Well, that kind of downplays reality. The defense at trial was that he was compulsed. There was a compulsion instruction given, a definition of compulsion. Now I need to ask you the following question. What is the import of the movement's ability to form a requisite intent when his defense is that he was compulsed to do it? He doesn't need to form the intent. He was forced to do it. That was his defense. But that's under the colorable claim end run argument. I hope I answered your question.
Yeah, I started to ask you earlier, but I guess it really didn't make any difference. But your argument that the actual document, the content of the pleading belies mental retardation. We had the same argument in Wynn, that the content of the motion belied inability to communicate, and we had the answer to that is that he had a jailhouse lawyer that helped him. But
I wasn't aware of that.
I understand your argument.
But and I understand that could be the answer. But I've been here before, and I'm here again. And you say it was a non-attorney. We don't know that.
Yeah.
We don't know who drafted this. And why is it important? It's important for here 3 reasons. All we've talked about today is whether the movement had counsel appointed. I don't know. That's important. You're going to liberally construe things because he's pro se. Was he? And here, and for the future, how are we going to do the issue of a conflict of interest when we don't know who drafted this prior motion? Things to think about.
If if we agree with you that the panel failed to follow some of our rules on exceptional circumstances, and they should have applied that paradigm, do we remand to the panel, or, because it seems to me that the next step is, if exceptional circumstances do apply, I mean, if that rule applies, that you have to establish it, they're finding that we're not even gonna look at exceptional circumstances because it's not statutorily mandated. Then the next step is, were there exceptional circumstances here? You see what I'm saying? If they applied the wrong
Right.
legal standard, do we send it back to the panel to apply the correct legal standard?
Honestly, Your Honor, I guess I've seen it both ways. I can't answer it any better than that. I've seen it both ways. You could do that. However, you could address it on your own, finding that exceptional circumstances should have been applied and determining that there were or weren't any exceptional circumstances. But I do have an issue that kind of touches on that, if I may. The last part of our petition was, and I think this is something that happens quite frequently as well, which is what we have here, as I understand it, is the district court judge has made a determination based upon a procedural hurdle. The district court judge has determined you did not cite exceptional circumstances. Therefore, you are procedurally barred on your second motion. Now, that is the ruling that is identified in the notice of appeal. That is the ruling that the Court of Appeals should review. What they told us is they're sending it back for a hearing. To me, that skips a step. What I believe the Court of Appeals should have done is, well, use your case law to determine whether there were exceptional circumstances. Should it have found that the district court erred in that procedural finding, should have sent it back down to the district court to determine whether there was a need for a hearing or not. Because that procedural bar is the only issue that was identified in the notice of appeal, and it's my understanding that's what the next level, the Court of Appeals or this court, would take jurisdiction, if you want to use the term jurisdiction, would take jurisdiction over. Unless the court has any questions in any aspects of this, I'll let Mr. Wayman come up.
I see none. Thank you,
Thank
counsel.
you.
With an IQ of 49, it was found that Mr. Littlejohn basically acted at a third grade level. At a third grade level, you know you did something wrong and you go back to get your phone, and then when you get caught, you tell a lie and you make something up. It fits. Who better would be compelled by another person and under compulsion than someone who is mentally disabled? I mean, it fits. On a compulsion defense, if the jury had the knowledge that he was mentally disabled, and especially to this degree, it may well have had an impact. So that's just responding to some of the issues raised by Mr.
Who drafted his motion?
I have no idea, Your Honor.
Does it matter?
No.
Why? I mean, doesn't the motion belie your position that he has an IQ of 49? It's well articulated, presents issues in a very comprehensive, meaningful way.
I doubt very much that it was by him. I mean, I would, Your Honor, I've handled, I believe, over 500 1507 appeals. I wrote an appeal once on a case that the entire petition was, I want out and I want $1 million. I have corresponded with clients who could barely spell their own name, but the petition was beautiful. For an extra cupcake, you can get a really nice petition written. There are people that spend all of their time working on other people's cases inside prison. It is not uncommon for what I see in my correspondence with people who are not very capable to have some very nice work done.
Can we get to the procedural aspects of this? It was filed, the motion, however beautiful, did not include a recitation or explanation of exceptional circumstances, correct?
That's correct, Your Honor.
And it was a successive motion.
It was.
Okay. The Court of Appeals said exceptional circumstances is not required by the statute, so we're not going to apply that requirement.
More or less correct.
If we disagree with the panel on that legal standard, that exceptional circumstances was required to be shown, what happens? What do we do with that?
I think a grave injustice occurs. I think we're looking at form over substance.
No,
You know, the way
I don't want an argument about the equities here. I want to know if we say you should have applied exceptional circumstances the way that this court just did in the Wynn case. Okay, so you're wrong. It applied the wrong legal standard. So what did we? But the motion didn't argue exceptional circumstances, and the trial court noted that and denied on that basis. So what do we do with it right now? If we decide that it should have been considered or analyzed as we just did in Wynn.
a couple of things. Number one, the Court of Appeals relied on the Salim 3, I believe it was, where ostensibly the Salim court equated the manifest injustice with exceptional circumstances, that the strength of the service of justice acted as the exceptional circumstance. That was more or less the analysis of the Court of Appeals in this case. And if we look at, if we do look at the statute, and this is really, yes, they kind of went around the exceptional circumstances language, but 1507D says a sentencing court may not consider a second or successive motion for relief by the same movement when the ground for relief was determined adversely to the movement on a prior motion, prior determinations on the merits, and justice would not be served by reaching the merits of the subsequent motion. They found all three of those factors. I mean, that's the language of the statute. The exceptional circumstances is a judicially created issue. Because even 1507C, successive motions, what that says is the sentencing court shall not be required to entertain a second or successive motion for relief. There is nothing statutorily nor by this court rules that says it requires exceptional circumstances. It is merely a discretionary act by the district court whether or not to consider a successive motion. And there are instances by the statute on when the court can consider a successive motion. So it's not wrong by the law and by what's in the statute. It's wrong by prior judicial interpretation.
Well, what should we, I guess as a matter of just how our judicial system works, how should this court respond to what is pretty effectively a Court of Appeals opinion that says, we know what the Kansas Supreme Court says, but we're not going to do it? I mean, the Court of Appeals cites to our decision in Kelly, which is pretty no nonsense, there's not a lot of ambiguity there, and then says that's wrong and we're going to go do something else. Now, even if they're right in from an analytical perspective, what's your view of how we should treat that?
I think this court, as it did in State versus Layton 10 years ago, has the ability to make a finding about what is just and correct. And I think in looking at this, when we have, and the reality is, he has an IQ of 49. Where's the third grade level? I mean, alternative, let's say he filed a petition, same exact thing, filed a petition, denied appeal, he files a second one, and what it says is, I have an IQ of 49. My attorney has a picture of my brother who looks like me committing the crime, and I forgot to include that in the first time around. And here it is. And here's the affidavit from my attorney saying, I forgot this. What do? You didn't say exceptional circumstances. Sorry, we have proof you're innocent, but we're not going to do anything about it because you didn't say, here's an exceptional circumstance. Is an IQ of 49 an exceptional circumstance? Is the fact that you're acting pro se with an IQ of 49 an exceptional circumstance? Is the fact that your attorney presented this exact information to the court, obviously knew about it, but didn't use it as a part of your defense in a compulsion defense? Is that an exceptional circumstance? Are there times when the injustice is enough to stand alone as an exceptional circumstance? Must we rely on specific words in order to make such a finding? And I think that's what it comes down to, Your Honor. Can the extent of the injustice itself stand as the exceptional circumstance? Because that's how I read the decision of the Court of Appeals in this case. That's how I've always read Salim. You know, I've included Salim in briefs probably for 8 years because I've always believed in their analysis that it's more than just words. It's about, and the distinction in the Salim case, he filed a prior 1507. He filed a second one after, or I believe this was actually the third. He hired counsel for the third one who came in and found all this discovery that really put his whole trial in question. And the Court of Appeals in that case said, wow, this stuff is so bad that we find a manifest injustice. And the extent of the injustice itself acts as the exceptional circumstance to get over this excessiveness, even though you didn't say exceptional circumstance. And it's an unpublished case. It's not one that made it to this court, obviously. And I think there's a righteousness in that. I think there's a correctness in that. That because, you know, in the same scenario of, you know, I have proof I'm innocent, I can show it. Sorry, you filed a prior 1507. We can't let you out because you didn't say exceptional circumstances. I mean, it's, you know, this isn't proof of innocence that the Court of Appeals granted a remand on. But it's pretty strong information that if we look at the purpose of a 1507, which is to assess whether or not an individual received a fair trial, their constitutional right to a fair trial.
Do you read the Court of Appeals opinion as saying, even though the magic words weren't recited, we look at this and find that exceptional circumstances are present? Or do you read the Court of Appeals ruling as saying, there is no exceptional circumstances requirement in this case?
I take it more with their reliance on Salim as the injustice. It either acts as or accepts.
There are parts of the opinion that seem to support both of those interpretations. I mean, at one point they say he shouldn't be required to show exceptional circumstances.
I like the other one. And I don't disagree with you, Your Honor. The language is a little cross. But I take the reliance on Salim Because I think that's the main point that they go to, that it's more of an equating factor of the injustice of the case, because they rely on the sub D and the 3 points. I think they take it through that more. They're relying more on the statutory question. And I think that's kind of where the language comes in, Justice Stiegel, about, the statutes don't require exceptional circumstances. So we look at the statute and he meets all of these points for it to be considered. But then when they get to Salim, I think that's where they kind of say this injustice acts as this exceptional circumstance.
The problem with that is that you are conflating procedure with merits. And procedurally, you have a 1-year limitation, or you have to show manifest injustice. Don't need to consider successive motions unless there's exceptional circumstances. And that's a showing of why the procedural rule shouldn't apply to you. And what you're saying is there's overwhelming meritorious arguments here that should remove the procedural bar. And so basically you're having to decide if this is a meritorious claim before you decide the procedural aspect of whether they get into court. Because what we're talking about is, do they get into court to make their argument, isn't it?
Correct.
And you're saying if they have a really, really good case, then they should get into court.
And I say that, but that's what subsection D says. That's one of the considerations for considering a successive motion, is whether or not justice will be served. I mean, that's in the statute.
That's in our Supreme Court rule.
I'm sorry.
That's not in the statute at all. It's in our rule.
I apologize, Your Honor. You're absolutely right. That was my mistake. Is that better? That it's something that you all have said and made a part of it? I mean, it's there, that it is something to be considered. And so, why not? Why, and if it is, because it's the whole point. And here, we're not talking about this is going to give him a new trial. This is a consideration for something that has been found to be potentially a very strong issue and potentially warrant a new trial. And this is a unique situation. This is not one that is going to, the fear of the great 60-1507 is the opening of the floodgates. This is not a big floodgate opener. This is one of those rare cases, like the Salim case, where we have a very unique defendant with a very unique issue that was on the record, known by counsel, but was not used as part of the defense at trial. What we don't know is why it wasn't. And we're also, none of the stuff was on the merits. We don't necessarily know why the first 1507, why the appeal was dismissed. And maybe it was because he wrote the first one himself and it didn't make any sense. But it was still timely. And this kind of goes back to, and I'm going to advocate on this forever. He's an IQ of 49, he's pro se. The state gets to write their response, which is clearly, word for word, adopted by the district court.
But you did petition for review on that.
No, Your Honor, I did not.
Yeah.
But I'm just pointing out that we are holding standards of magic words that these people don't necessarily, one, know about, or two, understand. We're holding a person with an IQ of 49 to the same standard that I have to meet. With all of my access to Westlaw and experience and knowledge and the number of times that I've been fortunate to appear before you, Kendra Littlejohn has to meet those exact same standards.
Counsel, we understand your position. Thank you.
Thank you, Your Honors. I'm done for the day. Thank you.
Just briefly, Your Honor. Mr. Whalen talks about the opening of the floodgate and so forth and so on. Well, I guess we have a couple things going on here. We've got a Court of Appeals opinion that contradicts your case law. That will be a floodgate. You will see it. You will see it all the time if you approve it. That is the kind of thing that floodgates are made out of. The next issue is the particular movement and the avenues in which he has to get relief and so forth and so on. I guess what I'm trying to say is if it is an exceptional circumstance today, it's an exceptional circumstance tomorrow. And what we do know is that there are multiple 1507s filed. He was denied on a procedural bar. He didn't tell us why it was an exceptional circumstance. There's nothing prohibiting him from filing another 1507 telling us what the exceptional circumstances are, and if he feels like, if I believe he would be out of time, why that is also manifestly unjust. Why can't we just follow the rules? Thank you.
Thank you, counsel. Thank both of you for your arguments this morning. Court will take this matter under advisement.